We are broadcasting live.
Thank you. Good afternoon, everyone. This is a special council meeting held pursuant to our procedural bylaw to finish the agenda that we attempted to tackle last week. As such, it is limited to basically unfinished business from the previous meeting. The meeting is being conducted both in chambers and by means of electronic participation as permitted in Section 238, subsection 3.1 of the Municipal Act 2001 as amended, and the Town of Mono Procedural Bylaw 2020-42. The residents have the option of joining us here in public today or virtually over the internet, either in real time or subsequently through YouTube. We do have a quorum. Location of emergency exits, for everybody's recollection, is behind the public gallery. Members of council are free to declare pecuniary interest at this point or at any point in the course of the meeting. And I'm going to call on Councillor Capes to deliver the Indigenous land acknowledgement.
We would like to begin by respectfully acknowledging that the town of Mono resides within the traditional territory and ancestral lands of the Teonatate, Adawandran, Haudenosaunee, and Anishinaabe peoples. We also acknowledge that the town of Mono resides within the treaty lands named under Treaty 18, the Nottawasaga Purchase of 1818. These traditional territories upon which we live and learn are steeped in rich Indigenous history and traditions. It is with this statement that we declare to honor and respect the past and present connection of Indigenous peoples with this land, its waterways, and resources.
Thank you. I have a motion that council approves the agenda of session 2023 as circulated. Do I have a, oh, sorry, Fred.
Your Worship, Director of Recreation has requested that we add to the agenda a third request for a rental subsidy. So that would go on with the two that have been published on this agenda.
Okay. As we're dealing with those, I think that's not inappropriate to deal with a third one. So aware of that, anyone to move the adoption of the agenda? Councillor Capes, Deputy Mayor Nix seconds. Any opposed with that amendment? That motion is carried. First item on the agenda is the amended bylaw enforcement policy. Pardon me. We just, no, I don't see a motion for approval of minutes.
No, the minutes from the meeting of less than a
Last
week ago, they're not prepared yet.
Okay, so they're coming for next Tuesday. Okay. Oops, I thought it was me. Okay, so they're coming next Tuesday. First item of business is the amendments to the bylaw enforcement policy, and you'll recall that this was something that I tried to tackle. And Fred, and then Melinda, then Councillor Capes.
Yes, thank you, Your Worship. I'm quite happy with the changes that have been made. I just would point out to the clerk, I have a number 5 or 6 very tiny, small spelling or other mistakes in the revised, in the red font draft. Just to give you an example how minor some of these are, the word complaint you sometimes use with a capital C, sometimes with a small c. Also the word council, sometimes with a small c. I think to be consistent, we should go one way or the other, but on more substantive issues, in section 2.2, you've got the phrase online complaint form. It should be complaint. In section 3.1, you've got the word this, which should be his. And in section 3.11, you've got the word an, A-N, instead of a. If you want me just to give you this list later, Fred, they're very minor, just to clean up the text.
I appreciate if you could provide me with that list, and I'll review the capitalization. The word council, of course, is unique because when it's being used as a proper noun, I capitalize it, but when it's not being used as a proper noun, I don't. And items that are defined should be capitalized, so if I haven't, they should be, if it's in the definitions.
I would just check.
Thanks. What Fred has described as a collision between my sloppy typing and automatic correction on the computer. Any other comments about the amendments to the policy, Councillor?
Thank you, Mayor. I think it's just great. We need to, enforcement's a really big deal. We need to organize it, so this is perfect. Thank you very much, Mayor. Reading through it, this is a great idea. We need to work on our enforcement. We need to work on our enforcement of our bylaws. There's no question about that. But I have an issue with 3.3. To my understanding, the complaint, I mean, the idea of privacy, the complainant calls, I mean, I know where this came from, and this came from the original complaint of Deputy Mayor Nix's as to what do I do when somebody calls me. But I'm not happy with this answer, in that if the councillor then becomes the complainant, it muddies the water with respect to exactly who's complaining, how many complaints are we having, what's any data that we may be gathering, because we now have moved to a computerized system where data collection is, endless as to what we might want to look at in the future. And if residents now know that, oh, well, we can just call the deputy and he'll do it for us, then our data just shows like we have a cranky deputy. So, so that's one thing. And then the other issue is with respect to where it goes after a complaint is made. It doesn't have anything to do with the council. Council should not be involved in it at all. We're not supposed to be, it even says further on, we're not going to give you any information, there's privacy rules, you're not going to find out anything. So then why am I getting involved? Like, why am I indicating to residents that I can help them? When in actual fact, I believe councillors and the council should be separate from this bylaw enforcement thing. And I might have, I gone on a few committees with some other municipalities, and nobody else is doing this. And so I kind of am thinking that I understand the complaint you had, but or concern, but I don't think that this is an answer.
If I could provide a little bit of context, and then I guess Councillor Capes is next. Yeah. I certainly get calls from people who do not want to be associated with making a complaint. So I have traditionally made the complaint on their behalf. I think the new policy speaks to the necessity to try and verify the validity of a complaint that comes to us, that we in turn assist the ratepayer in bringing to the attention of staff. It's not that we are saying that we can solve the problem or that we can affect anything other than getting the complaint on our official records so that it can be followed up. That's the intent there. And I think the order, and Councillor Mechtelot may want to speak to this, the order really should be that our first response is to alert people to the existence of the online form. If they still have an issue with filling out the online form themselves, and many don't, many aren't aware of it, so they're quite content to fill that out. If you then hit that impasse, then it's something that as a councillor may choose to do for the person, but I never promise anyone wondrous results, because as you know, these can be protracted and ongoing and difficult and tied up in the courts and all of that stuff. But I think the least we can do is show the residents how to either fill out the form or, absent that, make the complaint on their behalf, having satisfied ourselves that there is some validity to it. Elaine?
My point wasn't to that, but I can see both sides. And I do appreciate that when residents come to us, we are their closest link. And so I think it is beneficial if we can help them. And if by helping them means that we need to fill out the form, recognizing their name and their information is still going to be in that form, we've got their permission.
Held in confidence.
Yes, absolutely. I don't think it solves the problem that was presented before, that somebody didn't want to because the neighbor would know it was them. The neighbor's still gonna know it was them, whether it comes from a counselor or somewhere else. But anyway, I think I'm okay with that. But what I want to bring to our attention is, our DEI committee has met several times, and we're very conscious about language, and we're very conscious about fostering a sense of belonging and inclusion. And we have a bylaw before us which we can make some minor adjustments to take steps towards that. So point 3.1A says, of course, it says this or her, it should say their. 3.3.
Fred, are you making note of this?
I can send you a note too.
Yeah, I can, though I do have to admit, I try to avoid you now, and maybe that's just old language on my part, but to use the plural pronoun where I try to use he or she.
Okay,
And I
so
recognize
can
he
I
or
finish
she is
then?
limited.
Go ahead.
Okay, so the reason I'm saying this is because I want the language to be gender neutral. And so we need to stop using he and she and her, and him. We need to start using they and them and their. And so this is the reason for my ask. So there's 3 points in the document that I think we could change. So that's 3.1A, 3.3B, and 3.7. And I can certainly send you a note on that, Fred.
Ralph?
For 2 points. One is following up on Councillor Davies' comment. I'm not sure, John, from your answer, that I understand why the member, meaning me, once I've filled out the form, that I've deemed the complainant. Why is that?
Fred, is there a way that our role is as a facilitator as opposed to assuming the role of complainant?
Certainly not as imagined in this draft. It's either or. Either you're directing the resident how to file a complaint, or you're assuming the complaint yourself. Council does run the risk of, getting directly involved as both legislators when you're becoming an advocate for a complainant. There is the potential of that conflict of the separation of powers, which is why it hasn't been proposed as an option at this point.
Well, in terms of the separation of powers, if we are either facilitating or making the complaint, that presumably, with the exception of being briefed on outstanding cases, that brings an end to our involvement. We've handed it over to staff. So there is no separation of powers issue if once we've facilitated and/or become the complainant, that's the end of our involvement.
Right, so then perhaps I've misunderstood the point then. I thought the point was you were looking for, or debating the idea of having a third option where a member of council is involved more than either of those two.
In what sense?
Well, okay, again, maybe I misunderstood. Maybe I should raise that issue. I thought you were asking at this point to have a third option where a member of council could be an advocate to assist the complainant.
Facilitate the filling out of the form.
That's basically what
That's
what
all,
we're doing.
that's all.
But that works under point one.
That's point one. Yeah, I think we don't.
Okay.
We help them fill out the form, it's their name on the form.
Yeah, and but my point is that if they don't want to be associated with the complaint, I don't want to say, well, so sad, sorry, your complaint is going nowhere. because I think we're elected to advocate on behalf of our residents. So I'm trying to find a way of doing that without getting too much into the weeds here.
Thank you, Mayor. But, I mean, it adds the extra thing, because we do get a briefing on, we've just, in addition to in here, that we're gonna get a quarterly report on where things are. So then if we do become, 'cause I just see this as becoming okay, well, then that's the counselor that will do all your complaints for you. So then that's the counselor who will always have to recuse themselves whenever we're having legal advice, or not legal advice, but we're having a briefing on where things are going. And so then we've got somebody who's out of the mix should something happen, right? I mean, the whole reason why we get the briefing is because we do have power should something not be going along, properly or whatever. We don't, once it's moved to the provincial courts, we don't have anything. But within our own administrative situation, we do. That's kind of why we're getting briefed, right? If all of a sudden there was a whole bunch of outstanding ones and your numbers were all nuts that none of them had been investigated or something like that, then we would be able to make a direction. But you would have to recuse yourself if you were the complainant.
Recusal is up to the person that may be perceived as having a conflict.
Well, don't.
And under the Municipal Act, the only conflict that is recognized is for
Monetary.
pecuniary interest.
Okay, well, everybody's ethics and morals are different, but I would assume if you have become the complainant, and in the regular course, if the resident had stayed the complainant without you dipping in to help, they don't find out anything about anything. There are no obligation at all from the courts or the council or anybody or our administrative people to tell them how things are going, right? That's in this document too. You make the complaint and then you're at arm's length. But are you at arm's length if you're on council? It just seems to muddy it as opposed to helping it, which I think what we really should be doing is enforcing and educating people that, you need to get along with your neighbors. And if you really can't get along with your neighbors and you want to make a complaint, then you need to stand proud and make your complaint. And it's going to be anonymous in that, Susie Q down the road isn't going to know you made a complaint, but yes, you're going to be able to figure out if it's a fence line or whatever, that it's, Bob next door. But what we're trying to do with this, I think, is to have a community that gets along, not just has some other buddy step in to help.
Ralph, and then Councillor Capes.
Thank you. I think that my function has been described by others here quite adequately. It's to help the resident by filling out the form and then stepping back. And so if that's my function, then the last sentence of 3.3b, which is when a member submits a complaint in this manner, the member shall be deemed the complainant, is not necessary. So I would remove that. Before I lose it, I also want to point out that 3.3 puts the counselor, obliges the counselor to become involved. And in fact, that's not what we usually do. We usually say to the resident, fill out the form. There's a form and then go ahead with it. So I think that we're missing one recommendation, and that would probably be 3.3a, and it would read something like, recommend that the complainant submit the complaint using the online form. We should have that in there as an option. Otherwise, I'm committed to have to do something once I'm contacted.
Elaine?
So a question, because as a counselor, I can submit a complaint right now.
Sure, if you have one.
So why is that different than the complaint in this case?
I agree, and I've submitted quite a few, actually.
So it's kind of moot.
Do you want to become the complainant?
Well, I would be the complainant on mine, right?
You would be because it's your complaint.
Right,
But we're talking about if somebody else, another resident who has a complaint,
sure.
is not willing to fill out a form.
Well, in that case, they brought it to my attention, and I would only fill out the complaint if I agreed.
Yes, but do you want to continue to become the complainant then? Is there any purpose of that? We haven't heard of any value of that.
Yes, I would, because now it's my complaint. So I would accept that responsibility.
Fred?
I have to admit, Melinda and Ralph make some good points, which have given me some pause for thinking. But I think I'm going to side with what Elaine and John are saying, because it's been my experience. We have residents who, there's something wrong, and they phone you, and sometimes I go down and visit them, right? And you do get involved, and sometimes they don't want to be the complainant, or they can't, or they're too dumb, whatever. And so we do get involved and make the complaint. And I'm not sure, Ralph, that I see a problem with us both being the person who passes the bylaw and then makes a complaint under that bylaw. You know, isn't that part of our job? I think it always has been. So I'm sort of on this going to side with John and Elaine.
But as you mentioned, you submit the complaint, and then you don't have anything more to do with it, because it's the other person's, the resident's complaint. So
So it's the staff or the bylaw enforcement officer.
why do you want to become the complainant?
Excuse me, councilors, you're not being recorded right now.
Thanks.
Why, because my mic was off?
It was. Both our mics were off.
You're not streaming.
Can I ask a question? What's the role of the complainant?
Good question.
Apart from making the complaint, there is no role unless it gets to a court stage where our prosecutor may be looking for somebody to give evidence. Other than that, there is no role for the complainant. Am I correct in that, Fred?
With the possible exception of the bylaw officer talking to the complainant to get further information and understanding of the complaint.
And where is the harm in that?
Whether you want them to
harm
come to you to
of-
get further information? or-
If you're the one who filed the complaint and the bylaw officer wants to get the context of the complaint or what caused you to file the complaint, you can give, probably it's a short conversation, but apart from that and possibly being considered a witness at a POA trial or other trial, the complainant isn't involved, really. I mean, there's no ongoing role. And to Councillor Davies' point about our ability to review the case files on a quarterly basis, that's a very, in my experience, that's a very generic exercise. I mean, it's like we may have questions about one or two, how is this going, how is that going, what's the status of this cleanup? But, you know, I don't think I've ever been party to a discussion, and these are all in camera, where we give marching orders necessarily to staff based on, you know, a sense that nothing's happening with a particular file. Linda?
Thank you, Mayor. You're right, but legislation and rules and bylaws are meant to foresee the possibles and to avoid problems. And so to me, it just seems, if I'm not a counselor and I go ahead and fill out the form, I will never find out anything. And I'm thinking of somebody who, you know, has contacted us all and nothing happens, and, you know, I'm becoming vexatious because nothing's going on and so on. And so, but if I had just asked just claimed to the counselor or a counselor to say, well, you know, I don't want to say my name, will you fill it out for me? Then that counselor, it changes, that you will get all sorts of information and not be, like, I just think that it is the possibility of a problem down the road if we get involved. What's the point of being a complainant on your own anymore anyway with this new thing? Everybody would get to be anonymous forever because it's just going to be counselors.
Well, the other solution would be that council decides not to be briefed at all on the case files, and that we just leave it up to staff. But we have a duty to supervise staff in a generic kind of way through the CAO. So, I think we're foreseeing a problem that isn't going to arise, but the purpose of this wording is to make plain that when somebody comes to us, that You know, we're not to turn them away or tell them to fill out a form when they don't even know how to use internet or whatever, because the form is on the internet. And there are people out there who find that very uncomfortable to pursue.
The problem, if you see one, exists now. Because as a counselor, I will go on and I will fill out the complaints of things that I want to complain about. And they'll end up in the complaint bucket, and they'll end up in the bylaw enforcement bucket, and I will see them. So that issue exists now, whether we have this paragraph or we don't.
And there are those of us who will continue doing what we're doing on behalf of our residents. Ralph, and then.
So I still don't see why I should become the complainant just because I've filled out the form. And I think Fred has brought up an important point on it. And this happened the last person who complained, and they spoke to me about it. I didn't become the complainant, but it illustrates why I shouldn't, because the bylaw officer went back to see them to get more information about this. He wanted to understand what the complaint in greater depth, and I suspect that happens almost all the time. Mm-hmm. So it's not going to be useful to come to me because I don't know about this other activity. I won't describe it here, but the person who put in the complaint is the person who knows it. So they should remain the complainant.
But I think we can only confirm that they're the complainant if we have their permission. And what if they don't want to give it to us?
Again, how big is the complaint? How big is this problem? If this problem is so big that you want to get law enforcement involved on your neighbor or your other fellow resident, because a lot of complaints are, you know, somebody's driving by and sees something, right, a big sign or whatever, right? So the idea that you make a complaint, yourself, that it's going to be anonymous in that it's not going to ever be published, just has way more meaning than if everything ends up coming through council. But if everybody wants to, I mean, it's not like I'm not willing to do things for residents. What I think is the better thing for the town is if the residents actually are accountable for making complaints. And we wouldn't have people who made complaints that were unnecessary. We have to put your name to it. I'll show you how to do it. There's nothing wrong. Let's meet in the town. You don't have Wi-Fi at your place? In fact, you don't even have a computer? Come on down, I'll meet you at the town. But your name goes on it because it's your complaint. My name goes on it when it's my complaint. And I have to say that I would, at a meeting, if I really did have a complaint, which I don't so far because Mono's fabulous, that I would not be involved in a briefing from the lawyer because that puts me in a completely different position than somebody else, I don't agree with that part.
It's usually not briefing by the lawyer. It's usually the staff who do the briefing, and it's basically a review of the case files. What's open, what's closed, how many are open, how many are closed, and it's very generic. I mean, I'm being forthcoming here because people may be watching us, and you know. Mindful that these policies used to be written by staff. And this is maybe one of the first time that a meddlesome member of council has taken it upon himself to try and rewrite it. And I plead guilty to that, but I thought in the first instance it needed to be strengthened, and in the second instance clarified with regard to these very remote situations where somebody literally will not go anywhere near a complaint form, no matter how much you plead with them, no matter how much you try to convince them that they're going to be anonymous. Mm. But I plead guilty to throwing a wrench into the works, but I feel very passionately about our bylaw enforcement. And I think that the rules of engagement need to be publicized. We're certainly doing that, so that people know what the procedures are if they choose to make a complaint. Mike.
Thank you, Mayor. I think the content of 3.3B is definitely, the second sentence is, we're trying to avoid hearsay. We're really trying to avoid hearsay. I heard on the weekend that there was a bad situation and here's the complaint. What we're really saying to council, if you want to take this on as being the complainant, you need to have that firsthand knowledge, and then the decision becomes yours, whether it's a bylaw infraction or not. And that's what we're really heading, just as if you had seen it yourself, you're making yourself firsthand knowledge on it, and it avoids the hearsay. And I think that whether, Councillor Davey, whether that helps move that along a little bit, because then it becomes your own decision. If the resident doesn't want to get involved, it becomes your decision as to whether you deem it to be an applicable complaint on their behalf. Because if you don't, you're still telling the resident to fill it out on their own. So I'm thinking that that second sentence is really brings it to a level of, it's your decision now. We're not going to commit to the hearsay if you got it through an email over the weekend, which is 3 days past. We're asking you to make sure that you have that firsthand knowledge to deem it a complaint. So just like the email never happened, you become the visual inspection of that complaint, and you can make the complaint then. So I was wondering if the power in that second sentence
Are you referring to the second sentence of
in
3.3B?
3.3B, where we're
Why don't we just
basically.
take it out? Why don't we just
No,
take-
I'm saying
You're
100%,
saying-
I'm saying 100% leave it in, because it relieves that hearsay. I got an email and I heard this, and noise complaints are a typical one that you can't really have firsthand knowledge if you weren't there 3 days later when you got the email. And that's when it becomes very convoluted if a counselor puts in a complaint on a noise variation 3 days after the infraction. Whereas things like that should come from, unfortunately, the neighbor.
An eyewitness.
An eyewitness, right? And that's really what we're trying to get there in that second sentence is you need to look at the property standards issue yourself. If the resident that lives next to the issue does not want to put their name forward, and then it becomes really a decision of council themselves. So I think that's where Fred and I were really thought that firsthand knowledge had to be there, because it does, I get it, it does eliminate the initial complainer, but it does put council in a position that you are now the visual inspector of that and deem it a viable complaint. So I didn't know whether that would help Councillor Davies sort of see where we were headed with that paragraph B.
Thank you. No, I was aware of that. I was thinking of, like other kinds of complaints that, yes, you can go and see it, but yeah, no, the noise ones, of course, this would make it. So then what do? The guy calls you up, he says it's a bad noise, the people, and so then again, you're back with the, well, I'm sorry, we can't do anything about it.
No, they can file a complaint.
This is a guy who won't fill out the form.
He won't fill out the form. Well, he should know that it probably will go nowhere unless somebody's prepared to step forward and give evidence in a POA trial. I mean, that's where the noise ones are the hardest ones, quite frankly, because they're after the fact invariably, and you need witnesses who are prepared to say at 10 o'clock in the evening, I couldn't get to sleep because of this noise and that noise, and they can tell you what songs were being played too loudly and so forth. A lot of these, frankly, are property standards, and their zoning. The trailer park ones that are popping up. I found another one today, and I will probably be a complainant on that. But and those are much more obvious. They're much more apparent.
So, Your Honor, the way it stands now, if it's not an email and I or Fred's contacted by a resident, you're obligated to fill out the form. That's the way it's agreed right now.
What, we at council obligated?
Obligated, because that's what it says. It says the member shall, and go down to B, submit a complaint him or herself. What we need in there, I'm suggesting, is an additional one, which is that we do what you do all the time, is you recommend that the complainant submits the form on an online form. And if that's not in there, then I'm obligated to fill it out myself.
That suggests to me that we reorder A and B. We have a new A, which says that we, tell them about filling out the form and recommend that they do so. And then the next option is forward a written complaint to the administrator. And then the third option is submit the complaint himself or herself. Pardon me, Elaine. Their self. Does that make sense?
Yeah, I think Councillor Mantelo's made a good point, and I had made a note of it earlier, that this was predicated on if the councillor was going to accept this complaint. So I think it's a good point that there should be an option here for a member councillor to advise the resident to file the complaint themselves as the first choice, and then these two options if the resident elects not to do that and the councillor decides they want to take action, then they can advise them with the two A and Bs that are currently in the bylaw. So I agree, Councillor Mantelo. I think it's a good recommendation.
Yeah, I'll go with it too. I just wanted to point out, what is this, my 13th or 14th year on council, and I'm trying to think of the number of situations where this has arisen. And typically, yeah, noise, 11 o'clock at night, and I get in my car and I drive down to the OAS and listen. So I'm a witness, or they're clear cutting these trees, and I typically, I'll go look, or they're bringing fill in. In other words, the only instances I can think of where a resident has phoned me, maybe there's one exception to this, but by and large what happens is someone phones me and says someone's doing something, or they're not cutting the grass, or they're clear cutting trees. I typically go and have a look and then become a witness, and I don't have a problem filling out a complaint form in that case if the person doesn't want to. And I don't think, Melinda, to your point that, I mean, we've always done this. I don't think we're encouraging people to just anonymously make complaints and have us do the legwork for them. That hasn't happened with me.
We didn't say this in the enforcement bylaw.
No, we've been doing things by sort of practice in the past without a written policy so much as this.
I hear you, and I understand that in those situations, Fred. In a situation which is an ongoing problem on a property that the resident's been involved with, this happens to be the situation I've most recently been involved with. Residents have been involved with this for a number of years, and they have extensive knowledge of what's going on. And for me to become the complainant would be a disadvantage to the case. So if I suggest to the resident that they fill out the form and they're happy to do that, I think that they're in a much more powerful position.
Well, and when it gets to the state of witness at a POA trial, as an example, prosecutor will always defer to the best witness, not simply somebody who is, driving past and sees something. It's usually the person who lives right next door. Melinda?
But with this, you being the complainant and they won't know, I guess, unless you stood up and said. But then again, if they weren't even going to fill out a form 2 years ago about the issue, now when it finally comes to a trial, what's the likelihood that they're going to come and testify?
I think you face that, situation if it arises, and sometimes it doesn't even arise because there's compliance. And it doesn't go that far. But it got to the point of compliance because a complaint was made. Okay. Anything else? One of the major changes is 3.9, which is putting in writing what we used to do verbally. And I think that's really important in the interests of the person being complained against, is that they have something that is left with them. They can read it. They can see what bylaw they're alleged to have circumvented, as opposed to the friendly chat at the end of the driveway, which often has to be repeated time and time again, and still to no avail. So this is, I think, an improvement. It's not a certificate of offense. It is simply a notice that you have been the subject of a complaint. It's also good evidence at a trial that they were warned.
So do we put this forward now with some friendly amendments?
Do you have amendments to this section?
Well, I agree with Ralph's
Oh.
amendment.
Well, I'm just going through the rest of the bylaw to see if there's nothing else, if nobody has anything else, we can do friendly amendments, of course.
If,
I have
it
to
may
put a
be
motion on
easier
the
for
floor.
council if I could summarize the points I've taken and then just bring back, as opposed to trying to do pen and ink amendments here and
Okay.
now, I bring back a revised bylaw. So the three things that I have are, first of all, there's some editorial corrections to be made. There's the replacing all pronouns with gender-neutral pronouns. And then adding to section 3.3, an option for a member of councillor to ask the resident to file the complaint themselves.
Yeah.
Right. And those are the three changes that I've noted. Does that adequately summarize the discussion?
I'm good with that. Can it come back on Tuesday?
No, sir.
Is the spirit of this reworded policy being followed regardless?
Yeah, I would say so. Absolutely. I have received formal complaints from members of council, which may or may not be on behalf of a resident, because I wouldn't know and I shouldn't know in those cases. So council can tell me if the spirit's being followed.
Fair enough. Fair enough. Thank you. Let's proceed that way then. Okay, next item on the agenda is the Heritage Advisory Committee recommendation with regard to naming of the Fieldstone Parkette. And I, for one, think it's inspired. Yes. No, there is no question period for these special meetings. Well, there's no statement period for any of our meetings. There's delegations and there are questions. I mean, I'm following practice. It's not in our procedural bylaw. I have objected, frankly, in the past to special meetings where there hasn't been a question period. So I think it is something we need to address. But I'm we're too far gone into the agenda, Louis, to revert to something that is not recognized on the agenda. Okay, Louis, go ahead. We need you at the mic. At the mic. I have no idea.
They're dealing with the bylaw enforcement.
Yes, okay.
Where does the revenue come from in the penalties and the fines? We've had, for example, the fill bylaw. We had the right under the fill bylaw, $5,000 on the weekend if you fill. We had it with the motorcycles. They were told by members of council to senior staff, some of the people are in this room, don't levy the fines.
Okay. Can I stop you right there?
Just a second. So we gave back on the fourth line over $12,000 and then paid our own legals. Okay? This is a nightmare that is not being dealt with by anybody.
Louis, I have to correct the record from the last meeting wherein you suggested that we hadn't received any fines,
Oh, I didn't.
fine revenue, that you had had a discussion with the treasurer.
No, we did have fines
and-
from fourth line
Well,
to a
no,
point.
no.
Why did that, what was the point?
Let me rewind here if I can. I think I pointed out that we get fine revenue from Part 2 parking tickets, and we actually achieved quite a success in that for a short period of time while COVID was on. We also get fine revenue when we issue a Part 1 certificate on any of our bylaws. And the problem with that is that those fines are ridiculously low, and we're doing our level best to see that they are increased. If you lay a charge under Part 3, you do not get a fine until you get a conviction from the court.
What's
And-
Part 3?
And Part 3 is a process by way of summons. So it's a little bit more complex, and it's usually used for things like a breach of our zoning bylaw, as an example. And as for the fourth line, if you're talking about an undertaking there which involved fill and so forth, there were deposits made to the town, and we used a portion, if not all of those deposits.
No.
So it's not like, it's
It
not.
was $20,000. He got back, I think, 12.
Well,
Our legals didn't get paid. There was so much we absorbed.
unless we take somebody to court and sue them, sometimes you don't get back monies.
Why would anybody pay the fine then?
Yeah. It's a deposit. It's a deposit towards our consultants doing work,
But we-
our
the
lawyers
consultants,
doing work.
They did the work.
Well, I don't know if anyone can speak to this, but in the situation of our fill bylaw and we take a deposit, how does that work?
So in the case of deposits, they have to be for expenses incurred on the town's behalf to fulfill the application, and any expenses not actually incurred, the balance is returned. On the side of fines, Mr. Baker, unless a bylaw includes a fine, and a ticket can never exceed $1,000, and it has to be already prescribed and approved by the province. And if we want to seek anything higher than the set fine in the bylaw, we must go to court, but it's up to the court to then determine the fine. So for example, in the case of a fill bylaw, we do have a set fine of $700, but in a number of instances, we instead chose to go to court. And the
Through
court
Part 3.
actually, through Part 3, and the court actually assessed a fine of $700, right? So,
And this is the problem.
And in a case where we don't go to court, of course, we can't just arbitrarily issue a ticket for an amount. It has to be a prescribed set fine that's been approved by the courts. Nothing more, nothing less.
And we're doing our best, and including talking personally to the Attorney General about allowing for those fines to increase, because many of those fines have been around for 20, 30 years without any increase whatsoever. And nothing makes me madder than that, frankly. Very few things, anyway. So
You've had all
we're
these
doing
problems.
our best, and at least, Louis, have some confidence in the fact that you've got both staff and members of council who are on top of this and are aware of how the system works and are trying to get it changed.
No, nobody's trying to get it changed.
Sir, I take exception to that. Thank you.
Now I think we're on to the next item.
We're on to the next item. If you'd like to come forward on behalf of the Heritage Committee, that would be terrific. Thank you. And as I said, I think the recommendation here is inspiring.
Push the button.
Thank you. I'm Barbara Jafflis, and with me is Cosette Patnack, who wrote this. I think it's very important. I think that we're perhaps going to suggest something about being held in the month of February, which is Black History Month. I think it's important that we recognize the historical pioneers as such, and I'm pleased that council has received this. Cosette, do you want to say something?
No, I think
You're on.
I think that what I wrote sums it up. I'm very pleased that it looks like you are in agreement with me. The Parkette is close to that property, and see, it always makes me emotional. I think it rectifies a wrong, and it is good. And as I suggested, February is Black History Month. I think it would be really appropriate to perhaps name that park and make it public in that month, but that's not a recommendation, that's just an opinion.
And if you agree with the recommendation, I would like to suggest that you consider putting a plaque explaining the background, why we're calling this park that, and have it unveiled on the month of February.
Fred? Sorry, what was the wrong?
Oh, that he wasn't recognized as a Ketchum, he was not given that name, he was called Hannah's son. Although, yeah.
This question may seem redundant, but I think it's an important one to ask. And the question is, what is the essential reason for recognizing George Hannison? Is it that
He was the first black settler in Mono Township. If you read the little write-up, his background is the.
I read it, it's quite
Yeah.
interesting. Yeah.
It's the first in the Museum of Dufferin archives. He lived near the Parkette, like that was the farm. And he went on to be a contributing citizen, him and his descendants.
If I could just add to this, at the time that development was being considered and there were street names being considered, Hannison was one of the street names that was put forward, and it was never actually added to the list of street names there. So it was important to continue to foster that desire to recognize our first black farmer in Mono and the lands that he used to work here. So.
We were asked, in the Heritage Committee, we were asked to develop a policy for naming parkettes, and we wanted to make that policy as diverse and inclusive as possible. And I think naming this parkette after George Hannison is a step in that direction.
Can I make a suggestion? We have a possible motion to bring this into effect now, but maybe we could do an unveiling in Black History Month. Does that make sense? The right-hand side. There you go.
Never had that before.
Yeah.
Okay, so we have the motion now, which means we can pass this motion, but we could add to this motion that we are going to create a plaque and recognize this in the, do an opening in the month of February.
I haven't read the motion yet, but Kim and then, oh,
Sorry, just a point of clarification, is it Black History Month, November or February?
February.
Thank you, okay. There should be no challenges with getting a plaque made. I am presently looking at signage, like park signage. As you know, this park doesn't have a sign yet. And receiving quotations for signs for our parks, which will be included within the budget package. However, I will say that we will not be able to install a sign in February due to the nature of the ground at that time. So,
can we not pour a tube and have a metal thing that we can attach the sign to in February?
normally our signs are put in with, not a metal. I like them on nice 6x6 posts.
The post sticks onto the, I think, Matt looks like he knows what I'm talking about. Solenoid it's not sonotube, but the concrete, sonotube, with a metal protrusion that is capable of attaching a 4x4 tube.
3:25 p.m.
I don't know if I need to comment on it, but I know what you're talking about, but this, I think the wind loading from the sign, if it's loaded into the saddle, you might get it pulling out of there, so I'm not sure what Kim's done in the past, but I know it works, but,
I don't want to get bogged down on this, but why not just put the 2 posts up when we attach the sign in February?
Until I know the dimensions of the sign, it's impossible to put 2 posts in.
I think we should go ahead with the bylaw.
We're talking about 2 different signs, right? Your regular red kind of sign, they're red? I can't remember. Anyway, one of your red monopark signs, the conventional sign, which just would say the name and the town of Mono. But then the plaque, I'm picturing, when you say plaque, I'm picturing like the little short sign that is beside our new statue. Or a heritage thing, maybe there's something conventional in heritage that's a rectangle, because that one that you got was round. But it's 2 signs we're talking about, right?
Yeah.
So,
We can also put, like we have in our garden at Mono Center, we have a lovely stone, and we've put a plaque right on the stone.
Makes sense.
okay. We'll save us from ourselves. I'm going to read the motion and see if I have a mover and a seconder. That we introduce and give the necessary readings to a bylaw to name the municipal forming part of the lands described as Plan 7M59 BLK 115 Mono Ontario Fieldstone Parkette, the Hannison Parkette, that it be signed by the mayor and clerk for the town of Mono, sealed and engrossed in the bylaw book. And Councillor Capes moves, Councillor Davies seconds. Any further debate, discussions, construction comments? Seeing none, any opposed? Motion is carried. Thank you again.
Thank you.
Thank you.
February. Next item on the agenda is a motion by Councillor Capes regarding hunting in Mono. And Councillor Capes, was it your intention to go ahead with this today or simply introduce it to us? And
My intention was to have this motion go forward today.
okay. So shall I read the motion, then we can have a debate about it? Okay.
Direction to staff, what we said.
Whereas the town of, motion is, reads as follows, whereas the town of Motion is a place where citizens have the right to enjoy the peace and quiet of their home and to live in a safe environment. And whereas the sound of gunshots is threatening to some of our citizens who come from places where they were threatened by violence and trauma of war. And whereas council has heard from residents that they have felt unsafe from experiencing close calls of bullets on their back decks and sounds of shooting near their homes, so that they cannot enjoy their outdoor space and property, whereas hunting is permitted across the province, and whereas municipalities have authority to establish their own regulations regarding hunting, therefore be it resolved that, number 1, we commit to having a clear landing page for hunting information on Mono lands on our website, that this information specify dates, activity allowed, and list authorities to contact for concerns. And number 2, that we establish a bylaw regarding hunting in Mono. Regulating, pardon me. Regulating, and moved by Councillor Capes, seconded by Deputy Mayor Nix. Discussion.
Just one question and a comment. But my comment is that I have no problem with the bylaw, but it isn't, the shooting of guns, it isn't hunting that's quite often the issue. People shoot, the lady who appeared before us and who had that bullet through the glass, the guy was not hunting, he was just shooting at targets. It's shooting guns that's the issue, not hunting. But my question is, and I'd ask the clerk this, do we actually have the authority to regulate hunting on private property?
Municipalities do not have the authority to regulate hunting, but they do have the authority to regulate the discharge of firearms.
Even like on private property?
That's correct. But only the discharge of firearms.
Okay, then I think there's some wording changes needed here, because, and I think you would agree, it's not the hunting per se, that it's the shooting of guns.
Yeah.
Okay.
Go ahead.
Question about that, though, in terms of, yes, the discharge of firearms, that's great, but what about people who bow hunt?
What?
Bow hunt.
The province regulates hunting, and that includes through various methods such
Yeah.
as crossbows, straight bows. The municipality has the authority, and I quote, without limiting the other sections about bylaws, a local municipality may, for the purposes of public safety, prohibit or regulate the discharge of guns or other firearms, air guns, spring guns, crossbows, longbows, or any other weapon. So that's our authority from the Municipal Act.
Right, and that's what I would like it to include. All of those, they're listed. Discharges.
Thank you, Mayor. This is I thought this was, when I first read it, I thought this was let's look into this. While you're saying regulating hunting, that's pretty open. So we are not, what is it that you really want? No hunting in the town of Mono?
No, I don't think that's a reasonable request. I think it's to place some boundaries around hunting. It doesn't make sense, whether we call it hunting or discharge of firearms, as per the definition of what we can do, to protect people on their own properties. So in an area where you have a whole string of 10-acre lots, does it make sense to let somebody shoot a weapon that can travel further than their own 10 acres? It's those kinds of things. And maybe it's setting boundaries, maybe it's a lot size that needs to be specified. Maybe it's a boundary around where firing can take place or be launched from, So it's those kinds of things. I'm sure there are other municipalities who have similar things in place. And yes, it's going to be a fair bit of, let's take a look at it and find out. I'm not saying we restrict people. If somebody's got 100 acres and they farm on it regularly and there's no one next to them, they're not interfering so much with somebody else. But if it's somebody who lives on a 10-acre or 15-acre property and half of it is woods, and they can't go into their own woods because of fear that their next-door neighbors might be out shooting and shoot right into their own property. So that's the kind of thing.
Thank you for the clarification, but it's always, I may have the 100-acre, and the coyote is over, oh my God, he's by the fence line, and I'm gonna, right? Like.
There needs to be boundaries,
Right.
yeah.
Sounds tricky to me, but
Yeah.
we put it in staff's hands to come up with things. Is that the plan now, if we accept this?
No.
My recommendation to council on this would be that I bring back a report on what the process would be to establish such a bylaw. This isn't something that we've done ourselves. It's something we're going to need significant public input in. I've already been contacted by 2 organizations that express concerns over the hunting aspect, but are more than willing to be representatives of their constituents, hunters, in the discussions on a bylaw. So my report would recommend that, as opposed to bringing back a first bylaw drafted by staff, we go directly to establishing a public process to seek input. That would then lead to a first draft.
Having said that, though, I think that part 1 is really good, and I've advocated for it for years, that we have a very prominent location on our website, maybe taking up some of the ones that have been up a little long, and that it advertises the hunting periods, both for crossbows and shotguns and other things. Number two, I think we really do need a report on this. I'm already getting the phone calls from hunters who are concerned about it. And having lived through a successful attempt to get hunting prohibited in the county forest adjacent to Mona Cliffs Park, and that was quite a fight. And the argument there was that people didn't know the boundary between the park and the county forest, so people were straying from the county forest into the park and discharging their firearms in the park, or chasing the deer into the park. We were successful in having that stop, but we will get a lot of feedback on this.
It's good.
So may I make a recommendation that we strike out the second point and ask for a report from our clerk? Does that make sense?
Yep,
Is the mover and seconder agreeable to that?
yep, absolutely.
Okay. So it's clear that item number 2 is not being proceeded with as is, but rather in favor of a report from the clerk as to potential implementation of various options.
One question, do we need to change it from hunting to discharge of firearms? Or is this one specific to hunting and
Well,
just the website, and another one
We're
would?
just deleting point number 2, so I don't know.
So it
that
doesn't matter?
It doesn't arise, yeah.
Okay, thank you.
Thank you, Mayor. With respect to the hunting thing, I don't know whether everybody here, or it's just me, I get all sorts of notifications from the Dufferin Forest this time of year, starting in, what are we in? We're October now, starting in September. You know, regular emails that come to me to say that, you know, if you're going to be using, because I'm a mountain biker, right? If you're going to be using the forest, you know, be aware that at certain times and everything. The whole landing page info thing is an awesome idea. But one of the things that we need to maybe step up our social media, you know, awareness thing or notification thing, because so many people say, you know, I can't find it. It's like, it's right there. It's there. You can't see it. So maybe if we had things that were, you know, on a time manner, that at a certain time of year it now comes up, as opposed to Andrew having to change things, or that being there and it just being deep, or taking pages off, as you comment, that if there was some kind of a, you know, automatic data thing where that's the page, in October, it's the hunting page that doesn't matter what time of day you land on our website, but that's what comes up first, you know, and then it scrolls through something else, or whatever. Something that was automated to help so that the message gets out there that we are a rural community where there's hunting.
There was, however, an M&R change year ago, 2 years ago, where they flipped the bow season with the shotgun season or something like that. And a lot of people, you know, were unaware of that change. We also have 2 M&R districts in the town of Mono. I have no idea why, apart from maybe a biologist thought that there's a different species running around in one half of Mono as opposed to another half. But I think something that publicizes this is really good. I remember when I first started raising this, people would say, well, I'm a hunter, I know when the season is. That's not the point. That's not the point with respect. It's everyone who isn't a hunter, who doesn't know, and if you go to the M&R site and try and decipher the 54 different zones in Ontario, and it's huge and it's complex. But again, I've been told by hunters, oh, we all know that. Well, that's wonderful, but most of us don't. So I'm going to suggest that we vote on the motion minus that second point. Fred?
No. Your worship, if you want, as opposed to just deleting section 2, you could consider something along the lines of that we direct staff to bring back a report on a process to implement the discharge of firearms by law. Then at least the resolution states that you're giving direction.
Okay, I'm fine. I may have some problems once the recommendations come back, but we can certainly see them and consider them. Yeah. It's just a report. And for all the spectators out there in YouTube land, it's just a report. Any objections to the motion as amended? The motion is carried. Thank you. Now we have three rental subsidy requests. Fred?
Just, and I know this is a minor detail, but council like to pass a motion to add that to the list of unfinished business?
Yes. Moved by
so-
Councillor Capes, seconded by Councillor, yes. And any opposed? It's added to our list of things to do. Okay, Kim, we've got three applications, one a walk-on by the OPP. And by the way, I just have to raise this. Sorry. Okay. What is it?
I have a declaration of pecuniary interest
Oh,
in the
okay.
rental subsidy request for Headwaters Communities in Actions and Dufferin Community Foundation.
Okay, and that's,
Shall I read it out
no, I think you've been,
and just give it to the
Actually,
clerk?
it is a requirement to physically read them out, your worship.
Okay, so.
or to give reason, anyway.
Yep, the reason, I'm a coordinator for one of HCIA's projects and receive payment for services, and I also volunteer on the Not-for-Profit Association Week group.
In view of that, I should probably declare on the Dufferin Foundation, because my spouse is a volunteer for them. Does that preclude, Mr. Clerk, does that preclude me from talking about the other applications or the, more in particular, the application form?
No, you can still talk about the other applications and participate, and as for a general discussion on the nature of the form, that's still open for discussion if you wish.
Okay.
Can you, your worship, can you just repeat though for me, the actual declaration?
The declaration is on the application with regarding to the Dufferin Community Foundation, as my spouse is a volunteer on that organization. Unpaid.
So do you want me,
I'll file the paperwork.
do you want me to leave? Do you want to talk about the OPP one first and then I'll leave? What do you want to do?
So you, declaring a conflict, there's no requirement to
Leave?
leave, you just
Thank
can't
you.
participate.
Okay. Thank you.
I traditionally leave, so maybe let's do the OPP one first, and I'll get my comments in about the form. So any issues with regard to the OPP
I
application?
don't know what the OPP one is. No, we don't have it.
Yeah. No, that's correct, because this just came to our attention, I think it was Tuesday, for the OPP. They have come forward requesting rental space for November 30th and December the 8th at Mono Center in the banquet room. Both dates are for staff training for various things. It says here, one event is in relation to improving the criminal investigative skills of our frontline officers, which will have a direct impact on the safety and security of the residents of the town of Mono. This training includes bringing in specialty units to provide their expertise. The second training event, which would be December the 8th, is for all the supervisors of Dufferin OPP. This training is to improve the management skills of the supervisors, which will have a positive impact on frontline policing. Okay, so those are the two dates that they have requested. Banquet room upstairs for a weekday is $479. So the total request is $958 from the OPP.
Fred?
Well, I'll make a comment on that one, and quite frankly, my comment relates to all three, so I don't know if that gives Elaine and John a problem. I don't mind granting any of these three requests, but I am a little worried about something, Kim, because they're good groups, that's fine, we let them in there, but they use the upstairs banquet room of 107. We still have to have a caretaker go in there and sweep up after that. I mean, how many days in total are we looking at here? And the other thing is, of course, too, every time we grant one of these, we preclude renting the room out to somebody else. So
That's correct.
there's actually quite a financial burden to these requests. And what I'm wondering is, but whatever we do, I think we have to be consistent with all three of these groups. You say, okay, look, council said, fine, you can have the room, but here, at a minimum, you have to pay, $50 for the caretaker to sweep, whatever the number is. I'm not gonna not vote for these things, but I just wanna put that thought out there, that I'm just a bit worried about the number of times we're giving these rooms away for free.
Melinda?
Thank you, Mayor. I echo that. We pay a lot of money to the OPP. Government pays money to the OPP, right? I mean, that's where they make their money from us, right? They don't have other places where they make money. I think we have such nominal fees for these rooms, for these terrific facilities that we have, that I mean, if they're having training, how much are they paying the trainers to come and train these people, right? I'm sure that's thousands that they're paying. And so I have a problem with it. It seems we're just about to come to budget here. There's going to be millions that we're going to be looking for and cutting out of our budget and things like that, that all these little pennies add up. I have said that before, but I kind of feel strongly about it.
Kim, I don't know if you know, but this application may be moot. They've gone elsewhere. And they've got space for free.
Could I still add a comment?
And one of the reasons they went elsewhere was they took one look at this form, much of what doesn't apply to them or shouldn't apply to them, which is just, frankly, bureaucracy run amok, some of the questions, and they decided to go elsewhere. And that's my understanding. Go ahead.
I'd still like to add a comment that I forgot to add, with respect to the OPP in particular and their request for a free room. Hey, we now, as county councillors, have to have a criminal record check, and that costs money, and they don't give that to me for free. I can't remember what it cost, $45 or whatever. So we all had to pay that.
I just want to let council know that as of, I'm not sure what time your information came in, Mayor Krillman. I have an email here dated October 18th, 9:56 a.m. from one of our staff, Cheyenne, who does look after the bookings at the halls at the moment. And it says that she had received an email from the OPP, and they have confirmed both November 30th and December 8th with her. So have they changed their mind since 9:56 a.m. yesterday morning?
It's possible.
Okay. I just,
Okay, I take back what I said. I have confirmation here that Staff Sergeant Bulligan had put in a request through Cheyenne. And one of the advantages to training in Mono as opposed to the location they found in Orangeville is that they can leave quickly from the training session and get to places in the county faster than from downtown Orangeville. So the request still stands. I'm gonna exit, and you folks can talk about the rest of them. Over to you.
Does council want to pass a resolution on the OPP first?
Well,
On that?
just before we do, can I ask him, what bare bottom, absolute lowest, I mean, what does it cost to have a caretaker go in there and sweep up and put the chairs and tables back?
if I could just kind of backtrack a little bit on it, it's not just cleaning up. So for instance, we've got the initial phone call, the inquiry, which takes staff time. It then takes staff time to create a contract, send it out to them. We normally then follow up with them to make sure that they have signed it. In this situation, are we going to ask them for insurance, to provide us with insurance for these events? Because not for the OPP, but for the other ones, public are going to be on site. These are all things. Then we have the let-in we have staff that meet these people at the hall at whatever time they want to be there. We let them in. We give them a full rundown of how everything works at the hall, from how to lock the front door, where the lights are, where the heat is, if they want to make it warmer, if they want to make it cooler. We give them phone numbers to call if they have any problems throughout the event. Then we have the actual event happen. We then have at the end of the event where we put all the tables and chairs away. We don't ask them to do that. We want to do that ourselves so that we know they are clean and ready for the next function before they come out. We then do the full cleanup, which includes washing the floors, doing the kitchen, disinfecting everything. We go in. So for something as easy, I know it's very easy to say,
Made your point.
I think I've made my point. Okay.
I think it's reasonable to have a minimum fee. Because if we're saying we're not gonna charge full costs, I think we need to know what the minimum fee is and charge a minimum fee for all of what you just said. I would support that.
Well, I would argue that $500, $479, is the minimum already, because if I had a property, like an Airbnb, for example, where I was renting out to have people come and have parties or something, and there would be profit involved in that. And there's no profit in all that you listed, that $479, that's a bargain.
So shall we vote on the OPP request? Do I have any motion on that?
The motion I would recommend, Your Worship, is that we approve waiving the $958 rental fee for the Dufferin OPP to rent the banquet room at Mono Community Center on November 30th and December 8th, 2023.
And see whether that passes and then take it from there?
Mover and seconder.
I'll move it as a member of the Police Services Board looking for better service from the OPP.
I'm sorry, can you buy service?
Looking for better service. I think.
I'm sorry?
No.
I wouldn't have said that on record.
No, I think by allowing them to train in our midst, we are going to be the beneficiaries of that training. That's what I mean.
I'll second the motion, although I won't fight it, just to get it on the table.
So we'll call I'm not going to ask for a recorded vote. All those in favor of the motion? And those opposed? The motion collapses.
Now, could I put an alternative motion on the floor?
Absolutely.
The exact same wordings, waive the 900 and whatever, and replace it with $300. Well, it covers some of our costs.
Our cost is $479.
All right, and I withdraw. Fine.
I think. Anyways, this is the point where I really am going to absent myself.
But we haven't finished the OPP.
No, we did.
Oh, it's done?
It failed.
We can't put an alternative motion on the floor and...
Sure, if you want.
Well, I did, but Ralph was scared at me and...
I'll entertain an alternative, given that it's the same topic. Kim?
Of course.
One suggestion I could have is perhaps the OPP don't fall under our category of not-for-profit. So the rate that I've given you is the commercial rate. The not-for-profit rate would be $360 per day.
Oh, well, that's nice.
Per day.
Yeah.
So that's 2 days. Yeah. I'll put that motion on the floor. We give them the non-profit rate.
Seconded by? Melinda? Any further discussion? Those in favor?
Oh, do you have, no, I was voting in favor.
Wait
a second.
Yeah.
You're not voting, no.
This is the OPP. This is the OPP.
Oh.
We've just recast it as a nonprofit.
So which this is interesting. This is interesting before you go down the vote thing. The OPP shouldn't be for profit, are they? They should. I know that technically it's a government service. It should, but, so it shouldn't be for profit.
I think
They're
the motion
corporate.
only says give them the not-for-profit rate.
No, I know. So, but I'm kind of wondering that if we charge them, so because I gather the other two that are coming down the pipe here would classify as non-for-profit. And so it's almost like we're penalizing the police as opposed to saying that we're not going to favor them, but to have vetoed that when there is another, because I'm afraid I was not aware that there was another. So I'm waffling, but I think that they should be, I don't understand why they're a for-profit organization. How much profit do they make? This brings me back to my.
They don't make any profit.
They can't make profit, right? It's all got to be into service. Okay, so thank you.
Anything before we vote? All those in favor? Those opposed? Motion is lost. Okay, now I can leave.
Surprised me.
Point of clarification from the clerk. I do not have to leave the room. That's correct?
That is affirmative. You do not have to leave the room. You just can't participate in the
Excellent.
discussion.
I'll just be quiet. I can't make eyes either, right?
All right, I guess in the absence of the mayor, I will take the gavel. Does anyone have any comments on the first one, boy, I'm going to get the names all mixed up here. The Headwaters Community in Action, Dufferin, I don't know if that's the first or second one, but that's the one I got in front of me. They want it for 1 day, is it? No, just a minute. 1 day where the cost would be $360, and they want it at cost or free of charge. Now, maybe we could ask him, what does the word "at cost" mean? I mean, I know what it means, but what number would you put beside that?
So are we talking about the Dufferin Community Foundation event?
It's, my document says Headwaters Community in Action / Dufferin Community Foundation.
That technically was the next resolution, Deputy Mayor, but we can do them in whatever order you prefer.
Okay, let's deal with this one then, because just I happened to flip onto this page, so is that okay, Mr. Clerk?
Which one is
The Headwaters
Yes, it
Community in
is.
Action / Dufferin Community Foundation for a room.
No, they're two different ones. You just want
Oh, I
Headwaters
see.
Communities in Action.
Headwaters Community in Action is the first.
Well, you guys are ahead of me. I can't find that.
Okay. We can do them in whatever order you wish, Deputy Mayor. If you would like to do the
I under-
Headwaters Community in Action
I
/
understand that.
Dufferin Community Foundation, we can do that now.
I'm going to flip back up to the beginning of my file here because I'm totally confused. Oh, okay. Now I've got the one that only says Headwaters Community in Action. That's all it says, okay? And they're requesting a room on October the 19th from 5 to 9 p.m. The rate is $240, and they want it for free. Do I have any comments on this? Yes.
The question, I understand their position and purposes, but how are they, does anybody know how they are funded?
Elaine's recusing herself from this debate, but can you answer that question? How is Headwaters Community in Action funded?
No, she cannot.
She can't.
No, sir.
Can the clerk tell us how Headwaters Community in Action is funded? I
No, he
think they
cannot.
get some,
Not because I'm not allowed to, I don't know.
I think they might,
Is it not in the application?
I was supposed to ask for financial statements, isn't that
yeah,
what
we
it
are.
said?
I wouldn't be surprised if they get some county funding. But
So I expected to.
But it doesn't tell us.
That's grant.
Well, it says they get grants, but I don't know who they get them from. All right, we have incomplete information, but we still have a request for a free room that ordinarily would cost a nonprofit group $240. Any comments from two of you? Yes.
Thank you, Deputy Mayor. Yeah, my comments stand the same. I think that we already have a special rate for nonprofits. I think that it's going through, quite frankly, it's a half a day, but the whole process that Kim outlined for us for the day is the same, in that the contract has to get ready, the room has to get ready, and the room has to get tidied up. So, and we don't charge our.
Okay.
So, yeah.
Ralph, I'm going to put the motion on the floor.
I'm looking up their website, I can't determine.
The motion is that we approve waiving the $240 rental fee for Headwaters Community in Action to rent the lower south room at Mono Community Center on October the 19th, 2023, from 5 p.m. to 9 p.m. Do I have a mover
Also moved.
and a seconder? That was Mangtalo and Davies. Any discussion? All right, I call the vote on the motion. All in favor? All against? The motion fails. Do I have to write this down, or you've got that? Okay. I'll put it in this pile here. Boy, are we ever mean. So the next application I have is the one that has the double,
I see why you're confused.
yeah, it has two names on the organization. Headwaters Community in Action, Dufferin Community Foundation, and they would like the banquet room at Menorah Park, where the rental rate is ordinarily $360, and the application says they would like it either at cost or free of charge. Now, either Kim or the clerk, can you explain to me the motion is actually just going to say waive the $360 fee, but the application says at cost or free of charge. Kim, can you tell me what the phrase for that room at cost means? Do you have any idea?
I mean, I would have to do a absolute calculation on that by the time I figure out staff time, and then I do a calculation on the hard costs that we have of running the facility for those number of hours. I'd have to sit down and figure out a calculation.
No, I'm going to, with the indulgence of the two councillors who can vote on this, why don't I just put the motion as it's worded on the floor, see if I have a mover and seconder, and we'll vote on the motion. The motion that I have reads that we approve waiving the $360 rental fee for the Headwaters Community in Action Dufferin Community Foundation to rent the banquet room at Menorah Park Pavilion on February 21st, 2024. First of all, do I have a mover and seconder? Mangtalo and Davies. Any discussion of the motion? Yes, Ralph.
I think we all recognize this organization. It's just been around for a short period of time, and its raison d'etre is to raise funds and distribute them. It's kind of a mini United Way, you might say. And so we actually, I think we support it ourselves, and I know I do. So it's something that they have to pay their expenses, and then the rest of the money goes out to various organizations. So I think it's a very much a do-good organization here.
Melinda, any comments?
Well, I have a request, I guess, knowing how much in our budget, how much our staff, what our grid is, and thinking through the head and everything, I really do think that we're all basically at cost. And so I would request that maybe we do get a rough number like that, so that it can go, and for the future, so that it can go on the public, that, this is what we charge, and the reason why we charge it is because, it costs, and so that these waiving things, or these denials of waiving, don't make us sound mean.
All right, then can I ask the mover and seconder if we could make a friendly amendment to this motion that simply would read that we approve waiving the $360 rental fee and charge the at-cost fee for the Headwaters Community in Action, Dufferin Community Foundation, blah, 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 blah. If we inserted those words, and then we'll let Kim tell us what the cost is?
I would have to do a little investigation. I will let you know that the at-cost will be different for almost every event, depending on the number of people they're going to have present. So in other words, if you have 10 people at your event, and we only have chairs and tables to put away for 10, that's much different than if you have 200 people at your event. And our cleaning costs are absolutely different as well. So I can't give you a definite cost. And again, I will bring forward too the opportunity cost of lost revenue as well.
Okay, then that was just a suggestion. We didn't actually amend the motion. I just wanted to know if the mover and seconder would be agreeable to that. Putting that idea aside, does either Melinda or Ralph have any suggestion as to what we should do? The motion's on the floor.
I think we should vote on it.
I think we need to, yeah, I guess we should vote on it.
All right, all in favor of the motion? Against? The motion passes.
And then there's
Kim?
no discussion allowed? Can we ask? I mean, I think it would be a fruitful thing, and that we always are requested to have increased transparency from our big questioner. And I wonder if maybe that might be information that would be helpful, Kim, to have a range of, you know, what does it cost, just for our residents to know? Because the idea is that these aren't just random people coming from whatever. They're people that have something to do with the town of Mono as well, right?
One motion failed, one passed.
So that would be great if we could get that.
I've got that as an item to make sure we have it moving forward.
Thank you. Just before we leave this item, I have a question for Kim. I've been to a number of events at Menorah where the County of Dufferin has been the renter. Do we charge them?
Yeah.
Does that come before us as an application? They're not asking for any discount? Okay, good to know. Okay.
So I think we're up to Schedule A.
Schedule A. Lots of stuff on Schedule A. Does anyone have any, Elaine?
This is just a friendly request that when we carry over Schedule A from a meeting that we didn't complete, that we keep the numbering the same as the previous meeting so that I know, because in the previous meeting, I was prepared and I had the numbered items, and then of course, when I come to the new agenda, it's a different number. So for future, if we can keep the numbers identical to the previous agenda and add the other ones at the bottom.
That's reasonable, but it's never going to happen again, so.
Oh, I wouldn't say never. Anyway, that's just, I do have
Okay.
points, but I'll
Just-
let other people go first.
Anyone?
Well, I don't have the numbers, so I'm sorry, I have to say that I want to talk about number whatever and whatever. I just scrolled
Just
through what was
describe.
here and
Just
described
describe.
what I wanted to
Yeah.
discuss. The first one, please, the letter, there's no date on the letter regarding the automated speed enforcement. So you already sent that.
No, it's not been
You're
sent.
going to send it, so
hope.
it's on Schedule A, so, because this is an interesting thing.
It's a draft.
It does say draft across it, now you're right, I can see that. But this is an interesting thing, because when you went to AMO and presented, we didn't see the stuff beforehand as a draft, you just went on your own as it.
It was everything that we've been asking for years, so there was nothing new in our request to the minister or the ministry at that time. If there had been something new, I obviously would have brought it to council.
Okay.
On that same item, point D, it says 79 kilometers /R, then it says 80 kilometers /H. Is there
Typos.
supposed to be both say HR per hour?
It's kilometers per hour,
Okay, so they're both incorrect but
Yeah.
differently. Okay.
Fred, if
I
we can
just
make a
wanted
note
to-
of that.
just wanted to.
So then, if it hasn't gone yet, I think that this is, great. I think, it speaks to a letter later in schedule where yet another community has asked for this too. But we are, I think that, there's a whole, why are we just pulling out one thing this time?
Pointing out one thing?
Yeah, requesting one thing, one change.
We're addressing automated speed enforcement, traffic fines, and simplification of regulations. These are all points we've made in the past.
What about traffic lights?
Traffic,
Lights that we'd like.
that's an entirely separate letter. There's, I think, at last count, something like 15 requests that we have historically put forward to no effect.
Because there's nothing that stops traffic more than a stoplight with respect to speeding,
I agree.
Okay,
But we've traditionally done that as a separate ask.
okay.
And we did a delegation to Minister Mulrooney on that. And the automated speed enforcement was sort of a small item of that, but Mike was there and saw how well we were received.
So for Councillor Davey, so I've done Minister Del Duca, and I've also done Catherine Mulrooney in the last 10 years. There is a substantial list of safety issues, but I think the mayor's talking about the automatic speed enforcement is a separate issue, because ours were related to the turning and the ingress and egress from intersections, whereas this one's targeting their automatic speed enforcement. So, yeah.
And Mike has worked up a really impressive brief with photographs and maps, and everything's in there, signalization at Camilla, the disappearing traffic lane on Highway 9 at the first line. There's a whole host of things that he was encouraged to communicate with MTO offices on.
And generally, their response was, when it comes time for upgrades, they'd be more than happy to look at our concerns. So it's justified. They work off a manual on justification of upgrades, for sure.
All right, well, great, thank you.
Okay, anything else on the MTO letter? Similarly, this is a draft of a letter to the Attorney General, again, covering off issues that we have historically been asking for, with some new information from the standpoint of level of unpaid fines and so forth, but it's not any different than what I presented to him in person.
So it's a follow-up.
It's a follow-up and a way of introducing ourselves. Well, the first one was an introduction to the new minister, and this is a reminder to the Attorney General that he kindly said a number of times that he'd be in touch.
Great, well, they're great letters.
Okay. Anything else in, Ralph?
I have a question. It's, let me find it. It's about your letter. The request was for the 5 recommended objectives, and one of these objectives, I'd like to just bring this up from my personal and perhaps other education. It's a recommendation number 5, that we permit as of right secondary suites, garden suites, and laneway houses province-wide. And you point out that the Mono zoning bylaw has implemented number 5 for quite a while. And I wonder if we could have a little elaboration on that. The zoning bylaw is 160 pages, and I really had trouble getting through it.
I think Dave is on air now. Dave?
Thank you, Mayor Creelman and Councillor Michael. Apologize for not being there, but I'm trying not to infect everyone as much as I can, and I'm still coughing. I apologize. So, but anyway, to your point, Councillor Mantalo, I had a general note there. We don't call them garden suites per se, but we allow for secondary dwellings
We can't
in
hear
the
you.
area where they are. Oh, I'm sorry. Where? Can you hear me now?
I can, but
Yeah. Well,
Can you
Ralph's
hear me?
asked the question, so he
Okay.
can translate for us.
we do permit them.
Yeah. So So in the rural area, we allow secondary dwellings based on certain tests, lot area size being one of them. And we allow them too in commercial zones. So an ancillary unit, say someone has a commercial use, for example, and for whatever reasons, they want to have a unit there. Maybe there's, it's an important business of some sort. They could have an ancillary unit in a commercial facility as well.
Dave, we
you know-
can't understand anything. I'm sorry, it's not what you're saying, it's the technology.
What he said is that you can have a secondary dwelling based on lot area in a residential area or in some commercial areas. It's also allowed.
So
So,
there-
that
so
is not the,
that's not
sorry,
that's not what the letter says.
not the same
Not
as
sure why you can't
as
hear
of
me.
right. We do not have as of right
Yeah.
secondary suites in our OP or zoning bylaw, I don't believe.
I didn't think so either.
We have as of right secondary units where they meet the zoning provisions, a key one being lot area.
Dave, we're just,
But you have to meet the minimum.
we can't hear you.
He's saying it depends on minimum lot area.
Okay. So there's some degree of qualification, but it's not as wide open.
If you
as
have,
would like. Is that fair? No.
second dwellings are allowed on a rural area with minimum 10 hectares. So it is as of right.
The 10 hectares is a minimum.
10 hectares. Okay, so
We don't call them garden suites per se, but where there are secondary dwellings.
okay.
So they're not allowed, Dave, in our residential areas. It wouldn't be allowable there.
No, the only caveat is the Bill 23 provision for 3 units to a lot where there's municipal servicing. And that isn't germane for Mono at this point, given servicing with Brookfield in terms of where its status is not being, what's the word I'm looking for, assumed by the town. And that would be the key one there, but not at this point.
Elaine?
I can't translate.
This is a great question, and it was one of my questions as well. And I think what would be helpful is if we had, I don't want a big report, I just want a one-page that describes how we implement this in Mono, because I hear what you're saying, sort of, but I won't be able to find it, I won't be able to reference it, I won't be able to talk intelligently to somebody else about it. So like just a one-page summary of how Mono is permitting as of right secondary suites, garden suites, laneway houses, and that's what I want to understand. So a one little pager would be awesome. I don't know if that's too much to ask.
I think that's a great ask.
Yeah, I think so.
Nope.
And the other part of
That's fine.
that could be situations where it has gone to the committee of, where issues have gone to the Committee of Adjustment as an exception to what the zoning states, as a minor variance, and the frequency with which those are approved, which I think is fairly frequent, frankly. So I think we're safe with what we said to the minister.
Not fairly frequent. I think we've done one since I've been on council.
Okay, I'm
We've
aware
done
of
2.
Two? Have we done two? We've done two.
it.
I believe it's 2. But they come up on occasion.
And they're usually not unreasonable. Okay, any other?
Well,
Ralph?
I just want to add a little depth to, or not depth, but support for Elaine's request. This is something that's is coming down the tube, and we need to understand it, and we need to decide whether there's a place for it in Mono. I know one of my chums in Guelph, it's allowable there. I'm not sure what the situation is which allows it. In particular, he's put one in his backyard, and it's we all know that housing is becoming a massive problem for people, and that this is one of the solutions. So we need to be aware of as much as we can about granny suites, et cetera, and what the regulations are in Mono. Thanks, Dave.
I think too, Councillor Mantelow, we heard from East Garifraxa, I believe, that they have implemented this. I think so. We heard that at that planning session, but I might be wrong community.
So Dave, in your spare time, one page?
I can do that.
Terrific. Anything else on Schedule A? Go ahead.
I got lots. So, number 10, the Nottawasaga Valley Conservation Authority. Beautiful reports. Beautiful reports. I'm sure they're expensive. But what I don't know, and I probably should know, is how is the apportioning criteria determined? Like, where I read it, we are like 3.67%, but I don't know how that's determined. And so I don't know if anybody here can explain that to me?
Ralph or Fred?
The levy, what's the levy based on?
So,
I'm not sure what the levy is based on. Is it, Fred, do you know, is it based on assessment?
I think Fred has an answer.
The ministry gives each conservation authority the total current value assessment for their watershed. I will admit the one part of it, which I'm not sure that I understand, is how they divvy up Mono's current value assessment between the credit, TRCA, and NVCA. They may simply do it on the basis of area, and again, I'm not saying that's how they do it. I don't know really how they do that part. That wouldn't accurately reflect the current value assessment in each, because most of our current value assessment would be in the credit watershed. But in any case, somehow or other, they divvy up that current value assessment, so the NVCA ends up with its 17 municipalities. Here's the total current value assessment. Oh, and Mono's share is whatever you just said. 3.67%.
I personally would like to see that formula, just so I know.
Well, I told you the formula. I think you want to see the numbers.
I want to see the detail of how that
Is
sort
it,
of
is it
falls out.
the current value assessment in their coverage area as distinct from the full municipality? I would assume so.
Well, it's the total current value assessment for the town of Mono, split three ways, but how the split occurs, I don't know. Like, it's split between credit, TRCA, and NVCA, right? So,
But then there's areas of Mono that aren't covered by a conservation authority, are there?
no, there's one lot that technically is in the Grand River
Oh, okay.
watershed, and for regulatory reasons, they add that to CVC's territory, but
Okay.
other than that, we're all covered.
Okay.
The one thing I should point out is, of course, these current value assessments that are being used are based on 2016
Yeah,
assessed values,
Yeah.
which,
that's okay. Everything else is too.
Probably works to our advantage.
So further questions on that. The revenue generated by the authority is 31%, and that's on page 9, and I wondered how that revenue is generated. Is that fees from programs? And the budget numbers, is like too many pages of that to try and figure that out.
Yeah, I'm not sure I can give you a breakdown on that, but permitting fees are a big part of it. And there are other things that they do individually for municipalities, that's in category 2. And then there are camps like Camp Tiffin. They have days where they harvest maple syrup. And so there's a number of ways that they obtain funds. And I think they're pretty good at trying to do the best they can to get funds outside of municipalities. I think this is an interesting budget, because it's the first time you've seen a budget with category 2 and 3 separated from category 1. And this was a big newsworthy, not newsworthy is not appropriate, but a big item of concern when the government brought it in. And it's interesting to put some dollar value on it. It's around 10%. Yeah, and at the moment, I think I mentioned this at the last meeting. I think 8. We haven't had another NVCA meeting. 8 of the 18 or 17 municipalities have agreed to take part in paying category 2 and 3 assessments, and we haven't heard yet about the others. There's, I think, active discussions are going on. Mono has agreed to pay, of course. If we do not get the money that's required for 2 and 3, they plan to take it from reserves this year and then rejig it next year.
And again, to this, when I looked at the second report in there on page 9, the governance is a huge cost, and I wasn't quite sure what governance was made up of. I'll just make that comment. But the other comment I have is there's pages 11, 13, 15, 16, and 21 that all talk about achievements, and to me, they look like task lists of what we did and not what the outcome or impact was. Page 19 and 23 speak more to what the outcome and impact was. So that's what I would like to see more of. This is just my personal comment about that.
I'm sorry, are you still on the MDCA?
Yep. Maybe we can talk about that for your next meeting, Ralph. Number 13 on the agenda, the Canadian Community Building Fund. When I look at the agreement, it talks about the gas tax fund. Are they one and the same thing? I'm going to ask that to Les if I can through the mayor.
I think so. I think that's the new name for the gas tax.
That's the new name? Oh, yeah, so we're going to make a new name for it. Okay, no, that's great. I just was like, okay. Interesting, number 15, talking about the volunteer firefighter tax credit going up to $10,000. I think that's interesting, given that in one of our fire departments, we're talking about added benefits for volunteer firefighters. We might have to add that to the conversation. Also, number 16, yes, I think we should support that letter and also give them a copy of our own letter.
What number 16, what's
16 is the resolution for the
Automated speed enforcement.
amended, or for, automated speed enforcement. Number 17, the resolution from Aurora on opposition to strong mayor's powers. I wholeheartedly support that, and I have a question about, can we adopt here a motion, a resolution, a policy, whatever, to say that we will not have strong mayor powers in Mono? Is that allowable? That's my question. Okay, the clerk says it's allowable, so I'll be bringing that back. Number 18, definitely would like to support the guaranteed livable income, living wage. And 19.
When you say you want to support, are
Well,
we doing that in the
support,
form of a
our
motion?
usual support, meaning that we pass a motion to support it, send a letter, like whatever that good thing is
Do
that
we need
the
a mover
clerk
and a
does.
seconder for each?
Oh, do you?
Yeah, all of these things require motions to be formalized, and
So do I need to make a notice of motion on all these things to come back the next time?
Right on the floor. Right now. It's right in front of us.
but if that's challenging, then all of these could come back as notices of motion by any member of council. Either will work. And if I have a heads up, I can try to prepare. Sometimes I do prepare some if I think council might support it, keep it in
Okay.
my back pocket. I do not have that for this meeting on the, being a special meeting on shorter notice.
Yeah.
So I'm afraid I don't have one ready to go for you.
So to backtrack then on number 16, where I say I would like us to support that and send a copy of our own letter, that requires a motion?
All of those require motions,
So can I-
formal motions.
Thank you. Can I put that motion on the floor now?
Absolutely. Is there a seconder?
Well, can we actually
talking about-
have a formal motion?
Sure.
That's the tricky part, is on the
Right.
fly, coming up with a motion.
A motion to.
Which one are we on?
Number
I'm sorry.
16.
16, okay.
16 is the
Automated speeding enforcement.
from Cramahe Township.
Amendments to the traffic tax.
I don't even know where that is.
Can I make a suggestion?
Sure.
Let's maybe if we either have motions ready to go, or we can go back and create a motion that says the following, we support the following items from Agenda A, and that letters be sent to those municipalities indicating the support of the town of Mono, and then just do all of them at once.
I think ideally it would come back in a second meeting as prepared motions.
Go ahead.
Thank you, Mayor. I kind of think that that's a better thing to do, because not that I don't support, because we just are sending our own letter, but it's kind of like, who are we sending the letter to? Why are we sending it? How does it really do anything at all? Like they've had a motion and they've decided to send it to every municipality in Ontario. So presumably they send it all on the same day, and everybody within the same turnaround of the month is going to have a conversation around the table. But where does it go? What does our supporting it mean? So I don't understand that, to be able to on the fly say, yes, let's do something, because it might be meaningless, in which case it's already 4:30.
Well, it's.
So, do you know what I mean? Kind of, I'm thinking?
It means something to another municipality that
That
their
somebody else
resolution is supported.
supports. So.
Yeah.
Additional experience and additional information or pressure to Carolyn Mulrooney or whoever it is.
Because the letter isn't going just to the
Right.
to them, saying, hey, this is a great letter, we like it, yeah, go for it. It's that it actually still is going to the ministry, and so it's
Or to
a
aim at
more
Whoever we
voice,
direct.
more voices kind of an
Right.
idea. Okay, well, great, well, that
Okay,
sounds terrific.
so
Thank
I
you.
apologize for that, because in past, maybe there's only been one, and so,
But we've got a bunch
but we've
now.
got a bunch of them.
Yeah.
So I will do that. And I also want to support the catch and release motion from Midland.
Can I speak to that? This is a boilerplate motion that is making the rounds, that is predicated on, quite frankly, stories. We don't have any idea whether or not there's any validity to the stories. The fact is that statistics are not kept on the outcome of bail releases or police releases. Majority, frankly, are police releases, not bail releases. There are no statistics at all on what the justice system does when a breach occurs and the Crown has the ability to estreat the bail, in other words, go after the pledged amount. The court system does not keep those statistics, or if they do, they are a tightly guarded secret. So I will not support this because, again, this is just, pardon me, it's right-wing. The slogan catch and release is terribly misleading. It really is. But it's the lack of information, the lack of, I mean, if you were to ask me how many bail hearings result in a release versus a detention order, that information is not kept. When somebody breaches, that's not kept. And the consequences of the breach, no information on that. I've even done freedom of information requests of the court and of the ministry on some of this stuff, and I've gotten zero response because it's driven me crazy forever. It is.
But you do know that that the headlines when there's a crime committed by somebody who was out on bail or who was recently released, it's reasonable, just like some of these other things, livable incomes and things like that, that are, brought to the attention of people who want to find out more about it or change it or fix it or something. So to out of hand, I don't know, I mean, it is worthy, even though perhaps in this form, you may have seen it before and think that it's not. Like, it's hard to,
What's misleading about it is that for every instance where the system appears to go wrong, there's 20,000 examples of where it works. And we hear about the instances where it goes wrong. And sometimes it's misleading. They'll say the justice of the peace released this person who went out and assaulted somebody. And it turns out it was a Superior Court judge that did the release, not a justice. So, I mean, if you want a motion that puts them on the spot to produce the statistics that will either prove that we have a catch and release system or something to the contrary, I'm happy to write it. and my spare time. Now, let's not put it on the to-do list.
Thank you very much for
No, it's
indulging
okay.
me. Those are all
It's
my
okay.
comments
It's
about
very
the
easy- it's
Schedule
very
A.
easy to see, and I've had long discussions with our MP about the use of this catch and release expression. Because frankly, it's the police who are doing more of the releasing than detaining. Not a lot of people know that.
But again, it's a judgment call on the person who's making the decision at the time,
Oh, yeah.
right? Who, you assume that everybody is doing their best, but perhaps the system needs to be a little different, right? Well, I think that's the point ultimately of it, is not finger pointing necessarily, as the entire system could perhaps be improved with a unbiased view.
Well, and the other thing to be mindful of is that when the release happens, either at the behest of the police or the court, conditions are attached. Many conditions are attached. And that's where the breaches occur, is when the person can't live up to the conditions, the house arrest or the reporting condition to the police or whatever it happens to be. And when the breach occurs, we never find out whether it's a breach because of a paper condition not being adhered to versus an actual real offense that occurs. Again, lack of stats.
So, and lack of stats, because lack of, there's still lots of paper in our system, as opposed to real honest computer data that can be analyzed, right? So maybe it's coming, maybe things are better coming.
They have the ability to produce some of this information. Maybe not all of it, but I know for a fact they do. And, because I used to see it.
Seeing that notices of motion are not on this actual agenda, can I still make them? No.
Have to wait till
Thank you.
Tuesday. So anything else on Schedule A?
No, she said it all.
Yeah, she's covered.
Okay. Did we do the motion to accept Schedule A? I don't think so.
No, sir, it hasn't been moved or
Okay.
seconded yet,
Do
Your
I have a
Worship.
mover? Deputy Mayor, Councillor Davies seconds. All in favor? Okay. I'm glad that didn't go down to the feet. And do we have time for the closed meeting, Fred? We can always defer this.
That's up to you, Your Worship. If council wishes to defer, you can pass a motion to defer.
Can I make a suggestion?
Yes.
The agenda for next Tuesday doesn't appear to be that heavy, and it's already 4:30. Can I suggest we wait until next Tuesday to do that in camera?
Is it something that will
Oh,
wait?
sorry, I thought that was to your council. If council passes a motion to defer to the next meeting, it will be added to that agenda. And we do have an in-camera session already scheduled for that meeting, so it would be added to that.
Then I move a motion that we defer to the next meeting, the in-camera items.
I simply won't read the motion then. So we're deferring this to the next meeting.
Well, we do need
A motion to
a
defer?
motion, which Deputy
Okay.
Mayor Nix has
Okay.
moved.
And Melinda seconds. Any opposed? Motion's carried. A motion that we introduce and give the necessary readings to a bylaw to confirm the proceedings of Council of the Town of Mono in session 2023, held on the 19th of October 2023, that be signed by the mayor and the clerk and sealed and engrossed in the bylaw book. Do I have Councillor Capes moves, seconded by Councillor Davy? Any opposed? That motion is carried. And I have a motion that we adjourn this meeting at 4:30 PM, moved by Councillor May. 4:30. Yeah, no, pardon me, 4:40.
43.
Sorry, my battery's going low, so it's dim. Okay, 4:40, thank you. Moved by Councillor Davies, seconded by Councillor Capes, and that motion is carried.
All right,
Thank you, everyone.
good mega meeting.